It's great to be back with all of you. Welcome to February. And here in New York City, it is bright and sunny. I was speaking with some colleagues in our other offices. Sounds like in Syracuse, the sun is breaking through after some days that were a little bit darker, and so too in Albany. I don't want to take too much of your time because we have a full agenda here, but let me just walk you through. If Kathy, you'd go to the next slide, I can tell you what's coming up in the 45 minutes or so that we have with you. After I walk through a few brief updates, we'll turn to Tom Uron, who is back with us. Tom, of course, is our immediately past chair of our labor and employment practice, and with us from sunny Syracuse. And will be talking with us about the implications of the trustees of Dartmouth College versus the SEIU, just off or hot off the presses from the NLRB. Phil Gromit is with us from Albany. He is new to the program and relatively new to Bond. We're really glad that Phil will be able to address some property tax activities in the context of nonprofits. Natalie Vogel is back on the program, also with us from the Albany office, talking about OSHA and some new reporting requirements we want to make sure that all of you are up to speed on. Lance Willoughby Hudson, whose wall is just on the other side of mine here in New York City, will be addressing a New York City matter specifically, but that may have emanations, as a lot of stuff out of New York City does. And this concerns the Earned Safe and Sick Time Act Amendment, private right of action activity. But what happens in New York City may end up ultimately having relevance, to what's going on upstate. And so we just want to give everyone here listening in a chance to understand that. But let me just quickly tell you, in terms of legislative activity, we're going to keep the update just to a few comments right now. We're watching closely for those 30-day amendments from Governor Hochul. They haven't come out as of yet, but there may be a number of moving parts with regard to the budget. We don't yet know exactly what they are, but Kristen Smith and I, over the course of the balance of February, will be keeping all of you up to date. For now, though, let's just put a pin in that, as it were, and we'll turn to Tom Uron. Tom already is visible to the group here, and Tom's going to tell us all about this activity in the overnight. So we're really glad, Tom, that you can break it down for us. Please go right ahead.
Thanks, Gabe, and good afternoon, everyone. So pressed into service here. Yesterday, a potentially significant development for our college and university clients, as well as potentially for secondary schools and private secondary schools and other institutions. So we're talking in the private sector within the jurisdiction of the National Labor Relations Board. Last year, the Service Employees Union, the SEIU, which is one of the unions that has been very active in organizing new bargaining units, filed a petition with the National Labor Relations Board to represent the men's basketball team at Dartmouth. So this would be the union representative to sit down to engage in collective bargaining with the university over the terms and conditions of, quote, employment, close quote, of the men's basketball team. And yesterday, the regional director issued a decision finding that the basketball players were employees under the National Labor Relations Act and directing an election to determine whether or not they want to be represented by the union. Now, we've talked about this before. You may recall that in 2015, we had a similar situation with the football team at Northwestern University. There, the regional director also found that the football players were employees and had made a direction of election. But that case got appealed to the full National Labor Relations Board, and the board decided to sidestep the issue of whether college athletes are employees under the act, and simply decided to not exercise jurisdiction for a number of reasons specific to the Northwestern situation. But more recently, the NLRB General Counsel, the General Counsel appointed by President Biden, who has been a very aggressive advocate of union rights and expansion of the jurisdiction of the act has pushed forward with this theory that college athletes, student athletes, are properly considered employees, and at least in her opinion. And yesterday's decision is a real world example of that. So just a couple of minutes on how does the regional director, the general counsel, get to this conclusion. The definition of an employee under the National Labor Relations Act is frankly circular and not very informative. But the key elements are that the employer has the right to control the employee's work, and that work is performed in exchange for compensation. Now, here, there's a real question about whether the employee, the individuals, the students, the basketball players, are performing work for the university. And the regional director's approach on that was to say, well, they're providing benefit that generates revenue. People come to the games. TV networks pay money to broadcast those games. The fact that they wear the Dartmouth logo on their uniforms is essentially advertising, promotion for Dartmouth. It supports their continued operations, the ability to draw students into the organization, the ability to maintain good alumni relationships, and of course the revenue that's generated. Even though, to my understanding, this basketball team is last in their league, in the Ivy League, and it was undisputed that the basketball program, in fact, loses money at Dartmouth, that it is something that the university supports. Still, in the eyes of the regional director, this role as generating revenue and providing public face to support the university is providing services and is quote unquote work. And then for this work, the regional director concludes that the basketball players are compensated. Now, I think it's significant here that we're talking about an Ivy League school, Division I school, but still Ivy League, for which there are no athletic scholarships. The scholarship money that these players receive is in the same category of academic scholarships that other non-playing students would receive. But the regional director focuses on other perks that these student athletes receive and deems them sufficient to constitute compensation under the law. So they would include the fact that they have some additional access to the admission process. They have equipment that they receive, shoes and uniforms, and access to other facilities, workout facilities, practice facilities, as well as additional guidance, counseling, meal plans, etc. And the fact that the university so closely scripts and structures their day-to-day living particularly during the basketball season, that there is this conclusion from the regional director that it's work, and it's work that is compensated sufficiently to warrant their inclusion in the as employees under the act. And so the regional director has issued a direction for an election. Now, we can certainly anticipate that Dartmouth will appeal this decision. It's not the last word in this case, but what does it mean for other colleges and universities? And here, I think we need to take a step back, right? We need to remind ourselves that the rule of law, at least as put forward by the National Labor Relations Board, has changed significantly here, right? We have the CMAX decision, which under which the board decided that if a union submits a demand for recognition, the employer essentially has 14 days to respond to that, either respond to the union or to file its own petition with the National Labor Relations Board. And we're dealing now with the potential of our college and university student athletes being deemed employees and being subject to situation where the university it's a demand for recognition and needs to respond in much the same way that an employer, any private employer, would need to respond under the CMAX decision. So it's vital for our clients to carefully consider the implications of this decision in their on their campuses as it relates to not just basketball or football, but a host of sports. And my goal here today was to give you a brief overview to make sure you're focused on the potential implications and to announce that we will be doing a more in-depth discussion of this topic in a standalone webinar on Monday of next week. Look for information exactly. I had to leave the planning meeting in order to get on this webinar, but I understand it will be Monday, and look for specifics and a link to join that webinar. Thanks very much. Good to be with you all, and I'll turn it back over to Gabe.
Tom, thank you. Really appreciate the preview of what's to come in that Monday webinar. This is very important information that you're bringing to the audience, and for all those potentially affected. Glad that you flagged it, and more details to come next week. Let's move to our next speaker, who is Phil Gromit. And Phil, please turn on your camera and turn on your audio so we can see and hear you. Terrific. We are thrilled to have you with us. As I mentioned, Phil came to Bond fairly recently and hasn't had an opportunity to be on the program. So I'm very glad that Phil is taking the time today. Phil went to undergrad in Binghamton and actually law school here in New York City. We were just chatting about that before we went live with all of you. His work has taken him to the New York State Environmental Facilities Corporation, where he's done significant work around bond issuance and drinking water and sewage treatment related projects, for instance. An interesting fact that I noticed is that historically, from 2017 to 2019, Phil was actually a member, a former election commissioner of the Broome County Board of Elections. And so we're here today to talk about an issue that not-for-profits should have on their radar. I'm going to let Phil tell you more about it. And I'm just really glad, though, that Phil is with us to educate us, and with any luck, this won't be the last time you're on the program. Phil, welcome.
Thank you, Gabe, and thank you for that introduction. Good afternoon, everybody. We're going to switch gears here and talk about a not-for-profit issue. My presentation here today is going to focus on the property tax exemption deadline that's coming up on March 1st in most communities. I want to emphasize most communities. We're also going to discuss here the 420A and 420B property tax exemption that is available to nonprofits. These exemptions are by no means the only exemptions available to nonprofits, but they are two of the most broadly applicable and widely used. So we're going to summarize those two exemptions, and we're going to end with a discussion of some common issues to be aware of if you are seeking to apply for one of these exemptions or renewing them. So if we could, let's go to the next slide. where let's first do a little background here. Property taxes in New York are administered according to an annual cycle that repeats itself year after year. And that cycle is about to begin in most communities on March 1st with the occurrence of the taxable status date and the exemption filing date. The taxable status date recognizes that a property's ownership and physical condition is fixed for the remainder of the cycle. This occurs at the beginning of the cycle, and the condition and ownership of that property is fixed for the remainder. This is for, frankly, simplicity reasons. It would be too complicated to not have these issues fixed. And as we'll find out, and we're going to talk about in a little bit, because exemptions are centered in part around who owns the property, it follows that the property tax exemption deadline occurs on the same date. So if we go to the next slide, let's talk about this March 1st date. I don't want to go through this slide in line by line, but it's here for your review. And I hope what you take away here is that while March 1st is the deadline for nonprofits and the deadline for most exemptions to be applied for, March 1st may not be the deadline in your community, particularly if your property is located in a city. Cities tend to have property tax cycles that start and end on different dates. So what I want you to take away from this slide is that March 1st is generally, and in most communities, the date. Do not make this assumption. Be sure to check with your local assessor should you have any doubt or any concern. And be aware that if you miss this deadline to apply, the exemption deadline to apply for an exemption or renew an exemption, you will get a bad surprise in the form of a property tax bill, which no one would want. Let's go to the next slide and start to talk a little bit about the 420A and 420B exemptions. 420A is a mandatory property tax exemption. That means if you can meet the two main requirements we're going to talk about, 1 and 2 on your screen, you should get the exemption. I'm not going to talk too much about the pecuniary profit and profit-making comments at the bottom of the slide. We're going to focus on 1 and 2 in the middle. This exemption is available for the qualifying purposes identified at the top. 2 elements, 2 requirements. Let's go through them. The first, your property needs to be owned by a corporation or association organized or conducted exclusively for one of these purposes above: religious, charitable, hospital, so on and so forth. But ownership is not enough. Your property must also be used exclusively for carrying out or in furtherance of one of these purposes. Let's do a couple examples to help kind of bring this home. If a religious corporation owns a church and uses that property as a church, it should follow that they should get the 428 property tax exemption because the religious corporation owns the property and it's owned by an organization conducted for a religious purpose, satisfies the first requirement, and it's using the property in furtherance of and exclusively to carry out that religious purpose. Let's do a second example before we talk about 420B. Let's say that same religious corporation is gifted a property, a neighboring property next door, but uses the property for a coffee shop. In that example, the religious corporation can satisfy the first requirement. It's a religious corporation. It's an organization that's organized or conducted for a religious purpose, but it's arguably and likely not using that property exclusively for carrying out that religious property because it's a coffee shop. That in that example, that religious corporation would have to make a good argument to their assessor to justify that exemption. The important part to take away is that there's 2 elements. Ownership alone is not enough. There is a exclusive use requirement as well. Let's go to the next slide and talk about 420B. 420B is very similar to 420A. Same two requirements, there's two main differences. The first differences should be obvious. The qualifying purposes are different. 420B is applicable to benevolent associations, medical societies, etc., little leagues, perhaps. The qualifying purposes are different than 428, but the same two elements apply. It needs to be owned by a corporation or organization, organized or conducted exclusively for these qualifying purposes and used exclusively for carrying out these above qualifying purposes. The other way 420B is different is that it is a permissive exemption. That just means that the local community can adopt a local law effectively banning the application of 420B in that community. However, the law requires that any such local law or ban be an all or nothing ban, meaning that you can't single out a particular property, can't single out a certain qualifying use on this list. You have to ban 420B in whole or not. And for that reason, it's my understanding that 420B is a property tax exemption available to nonprofits in most communities. But again, check with your assessor, especially if you are applying for the first time. Let's go to the next slide and talk quickly about the application and renewal process before we end with some common issues to be aware of. What you should take away from the slide is that you need to initially apply for the nonprofit 428 or 420B exemption before the deadline, which in most communities is March 1st, like we talked about. And then you need to renew it on that property tax exemption filing deadline anniversary on the next cycle, and every cycle thereafter should you want to keep it. It's hard to do the initial application. The renewal process is generally streamlined in most communities. To apply, you'll have to submit an application that goes to your organization's purpose and whether it meets the qualifying purposes we've mentioned. And you have to submit an application if you're doing an initial application that goes to your use of the property. And you'll likely have to submit lots of information, including filings and returns you may have made to the IRS, corporate organizational documents, as well as any approvals, consents, authorizations your organization has gotten from a New York State agency, perhaps a state ed approval. But once you're in the door, the renewal process is easier. In most communities, the renewal process is streamlined and focused primarily around any change in use and confirming that you have not changed the property's use. Let's end here with a discussion of some common issues. If we could go to the next slide. So these are some issues to be aware of in applying for and keeping the 428 and 420B exemptions. The number one issue that comes up as far as why nonprofits do not get one of these exemptions is that there's a change in ownership, and it's as a result of circumstances where it's not so obvious that a new application is required. Let's do a couple examples. First, a nonprofit buyer buys from a nonprofit seller that has the same qualifying purposes. The seller has the exemption. The buyer thinks, well, the seller's gotten the exemption. Why? I don't need to apply. I'm doing the same thing. That would be incorrect. Anytime there's a change in ownership, there needs to be a new application. It's another example, even less obvious, a nonprofit with one of these exemptions, 428, 420B, transfers the property to an affiliate. Do not assume and do not expect that an assessor is going to know that it's affiliate or that it's going to know that are going to do any investigation frankly into it. If there's a new property, a new owner, a deed, that transfer should be accompanied by a new application for the 428, 420B exemptions. We'll end here with a discussion here on the partial tax aspect to these exemptions. 428 and 420B can be partially granted and partially denied. So that's something to be aware of. I'll end with an example that has been adjudicated in a court. The hospital with a parking garage that it's used in furtherance of its hospital qualifying purpose under 428 has the 428 exemption. but one day it decides to lease that parking garage, half of it, to a non-qualifying for-profit professional corporation. That hospital just put half of the value of that parking garage in jeopardy as far as the exemption, and what could likely result in that situation is half of that parking garage is taxable and half of it is exempt. Just an issue to keep in mind as you run your nonprofit throughout the year. I apologize for going a little over. If you have any questions, feel free to reach out directly, and I'll turn it back to Gabe.
Phil, really glad to have you on, and thank you for walking through those intricate issues relating to property tax and the types of items that should be front of mind if you're a leader in the sector with not-for-profit leadership. There's so much to think about all at once, and we're here to help if you're looking for guidance. And Phil, please come back on the program to keep us updated on issues such as this. Let me turn to our next speaker, who's back on the program. It's Natalie Vogel, also out of Albany. And Natalie is focused on employers in all aspects of labor and employment law in her practice, and also has some litigation as part of her broader portfolio. She's here to talk with us about OSHA. And that agency, which is front of mind for many of the organizations here that come to the webinar, has some new standards out around recording, and we want to make sure that all of you are familiar with them because if the word didn't reach you, this is a good opportunity to get caught up. And with that, I'm going to give you the floor, Natalie. Looking forward to learning more along with the audience. Thank you so much for being with us.
Thank you for that introduction, Gabe. As Gabe said, I am a labor and employment associate at Bond's Albany office, and I'll be talking to you today about a new OSHA reporting requirement. Kathy, if you could please go to the next slide. So earlier this past summer, OSHA finalized the improved tracking of workplace injuries and illnesses rule, which ultimately took effect on January 1st, 2024. And the rule requires certain high hazard employers with 100 or more employees to electronically submit OSHA forms 300 and 301 by March 2nd of each year. So as the rule took effect in January 1st, 2024, the first filing of these reports is due March 2nd of this year, 2024. Kathy, if you can please go to the next slide. So some high hazard employers that are included in this new rule, and this is a non-exhaustive list, it's mostly focused on healthcare clients, but the list is very broad. This is Appendix B of the new rule. So what OSHA did is they classified industries by their NAICS, which is the North American Industry Classification System. And that is the standard used by federal statistical agencies in classifying business establishments for the purpose of collecting and analyzing statistical data related to U.S. business economy. So here is listed some healthcare industries such as ambulatory healthcare services, general medical and surgical hospitals, psychiatric and substance abuse hospitals, nursing care facilities, residential, intellectual and development disability, mental health, and substance abuse facilities. And there's some other industries that I just could not fit on this one-page slide related to healthcare, such as continuing care retirement communities, assisted living facilities for the elderly, vocational rehabilitation services. And again, this was just a non-exhaustive list, primarily focused on healthcare industries, but there are many industries outside of that. And just for example, some include automotive parts, accessories and tire stores, grocery stores, school and employee bus transportation, amusement parks, just to name a few. But again, the focus is on the NAICS identification. And a full list of this can be found on Appendix B of the rule. If you would like a link to that, please let me know. I'd be happy to send that to anybody. Kathy, if you could go to the next slide, please. So the forms that are required to submit under this new rule are forms 300 and 301. I know most employers already maintain these forms, but this new rule focuses on submission of these forms to OSHA. So Form 300 is the log of work-related injuries and illnesses. So that includes a description of the job employee title, the date of the injury, where the event occurred, a description of the injury, and other information. And then Form 301 is the injury and illness incident report. So that will include a description of information on what the employee was doing before the incident, a description of how the injury occurred, substance or object that directly harmed the employee. So that might be a ladder or a chemical that the employee was working with that resulted in their harm. Kathy, if you could go to the next slide, please. So these forms, as I mentioned, need to be submitted electronically. So OSHA set up a new website, the injury tracking application for employers who are covered to submit these forms. And they identified 3 ways to submit them. The first is using the ITA web form to manually enter the data. That's where you log in, type all the information and submit it. Uploading a CSV file to the ITA if you maintain information separately and just upload that document right to the website, or using an application program interface fee to transmit the data electronically. Now, since this website is new and employers might not be familiar with all these different technical aspects, OSHA also has posted step-by-step guidance on uploading these forms and has contact for any electronic problems that an employer may have when uploading those. Again, if you would like information on this, feel free to reach out. Kathy, next slide, please. So OSHA plans to use this information in the forms to analyze workplace injuries, but they also plan to make this information available to the public. So that brings the issue of protecting an employee's personally identifiable information. So OSHA instructs employers when submitting this data through the ITA to not include employees in personally identifiable information. So that includes the employee's name, their social security number, phone number, address, email, or any other information that could lead to the identification of an employee. However, OSHA does instruct employers to submit the date of birth of the employee, but they note that the ITA will automatically convert the date of birth to age to protect that employee's identification. And in further steps to protect employee identification, OSHA will use automatic information technology to detect and remove any remaining information that either the employee accidentally kept, forgot to remove, that may lead to identification of the employee before posting the data to the public. Kathy, if you could go to the next slide, please. So when we're talking about OSHA forms 300 and 301, we've also had employers question, well, what are their obligations of filing OSHA form 300A under this new rule? This new rule does not impact employers required to submit OSHA form 300A, which is the annual summary of work-related injuries. And just as a reminder, employers that are required to file that form are employers with 250 or more employees that are required to routinely keep OSHA injury and illness records, and employers with 200 to 249 employees in certain high hazard industries. Again, the high hazard industries are classified by NAICS, and they are actually Appendix A to the new rule, a full list of those employers. So they contain the ones I previously mentioned in regard to this new rule, but there are also various other industries that I did not touch upon. So if you would like a link to that full list, please reach out and I can provide that. And then next slide, please, Kathy. And then here's just a final slide of takeaways. So the first step is going to be determining if you are a high hazard employer subject to this new rule with 100 or more employees. And then if you are, you should begin to prepare forms 300 and 301, ensure they are submitted on or before March 2nd, 2024, which is the deadline this year, and then annually thereafter for each year. All right, that's all I have today. So I'll pass it back to Gabe and I'll address any questions that I can in the chat.
Thank you so much, Natalie. There are several questions that came in through the chat, and if you're able to put some of those links out there for audience participants, I think that would be very helpful.
Yeah.
But again, this is clearly an issue that's been of interest and help. Based on the chat alone, it looks like there are a lot of folks who are learning about this and certainly appreciative of the update you provided. So thank you, Natalie, and please come on back if there's new information related to this or anything else that you'd see as important to present upon to the audience. So with that, let me turn to our final speaker for the day, who's Lance Willoughby Hudson. And as I mentioned, Lance sits just next door to me here in New York City. And Lance is with us and back on the program to talk about New York City's Earn Safe and Sick Time Act, and specifically mandatory language concerning private rights of action. What I was mentioning at the opening of the program, I just want to remind all of you about. What happens here in New York City doesn't necessarily at this moment apply to the full state or let alone the national conversation, but often New York City sets trends in spaces like this. And so we wanted to keep all of you apprised, even if you're outside of the 5 boroughs or otherwise your business isn't here. And Lance, we're really glad to learn along with you. I just want to remind all of you that not only does Lance sit right next door to me, but focuses in a variety of areas in his practice, workplace issues, elements of compliance. Lance went to Hofstra University School of Law just nearby here in Long Island. So Lance, really glad to have you with us. Please go right ahead. Thank you.
Thank you, Gabe. Hello, good afternoon, everyone. Like Gabe mentioned, I'm going to talk about a new amendment that the New York City Council made to the Earned Safe and Sick Time Act, which is essentially known as ESSTA. Well, first, just to kind of give a heads up, next slide, please, Kathy. So the decision to amend the act was on January 20th, 2024. And the biggest change was the ESSTA allows employees to have a private right of action for any violations of the ESSTA. And it's going to go into effect on March 20th, 2024. So essentially, employees will have the right to file a civil action in the state court here in New York. But currently, if you're not familiar with it, employees are required to file a complaint with the Department of Consumer and Worker Protection, which is known as DCWP. So starting March 20th, 2024, any allegations of violation of the ESST within 2 years of the date the employee knew or should have known of the alleged violation can be filed with the DCWP or with the state court as a civil action. Next slide, please, Kathy. So just to give you a reminder before I go into the potential recovery someone can get under the ESSTA. Currently right now, the ESSTA requires employers to either allow employees to accrue or front load time for sick leave. So that's the essence of the law if you're not familiar with it. But now, since employees have the right to file this complaint in the civil action, I just want to go through some of the recoveries that they can receive if indeed it's found that it was an actual violation of the ESSTA. So the first thing that an employee can recover is 3 times the wages if there is found to be a violation of the ESSTA, or $250, whichever is greater for every instance where an employee is not compensated properly by their employer for safe and sick time taken. So that can really add up because it's based on each employee in each instance. So it's really important to kind of follow all the new regulations. And the next big thing is $500 for each instance where a safe and sick time request was wrongfully denied. And then the next recovery for an employee is full compensation for wages and benefits lost, plus $500 in equitable relief for every instance of retaliation and interference. So just kind of to sum that up a little bit. So for instance, if an employer is found like violating or trying to prevent the employee for taking their right to have safe and sick time, they can be charged this amount. So any type of retaliation for that, or if an employee took it and it was approved, and then the employer does any type of action to retaliate against that employee, they can be found liable and the employee can recover for this. The next recovery that the employee can receive is $2,500 of full compensation, including wages and benefits lost, and equitable relief for each instance of unlawful employment discharge. So that's a little bit more self-explanatory. So basically, if any employer fires someone for taking their safe time off or sick time off, they can get that amount for recovery. And the last recovery that's possible for an employee who files a complaint for an ESSTA recovery is $500 for each employee covered by a policy that is not compliant to the ESSTA. So I guess this one would be kind of like a coverall for employers who just do not have the correct policy in place from the get-go of the creation of the ESSTA. So it's really important just to keep things in mind as far as your policy and just make sure practices are right to adhere to the ESSTA. Next slide, please, Kathy. So in addition to some of the recoveries that employees can receive, there's also going to be some penalties in place against employers who violate the policy. So the first time amount that would have to be paid to the city is $500 for the first violation of accrual and use of sick or safe time or retaliation per employee. And again, that's per employee. So it's not just based on just the practice of doing this, but it's based on each employee who files a legitimate complaint. And it's going to be $750 for subsequent violations that occur within 2 years of the previous violation, and is not to exceed $1,000 for each succeeding violation. So when you look at this and see all these changes, it's really kind of a burden on employers, and it kind of is like a signal to go ahead and look at your policies and just make sure you have everything in place that will be compliant with the ESSTA. So that could be anything from handbooks or just practices among supervisors as far as granting sick and safe time off. And the city council hasn't really given out a reason as to why this was amended. But if I had to take some educated guesses, I would assume that the DCWP was probably getting overburdened with complaints from employees. So I think that's one reason why they amended this law. And another reason too is I think they want to just make sure that employers are actually adhering to this law. So if you add the option of filing the administrative complaint with the DCWP and in the state court, then it'll put a lot of pressure on employers to just kind of be compliant with this new law and just making sure that each employee is properly using and accruing their safe and sick time. And one thing too, I want to point out, I mentioned it in the beginning, but you can file both the civil suit and the DCW complaint as well. And if it's the same allegation, the DCWP will stay their investigation of the complaint. So essentially, if someone files a civil suit and they already filed a complaint with the DCWP, it won't be two processes going on at the same time. So the civil complaint will go forward and the administrative DCP complaint will stay. And once the final determination is made for that civil suit, either a dismissal because it wasn't a valid complaint, or there was some type of settlement or anything of that nature where the complaint is complete, the employee has like 30 days to inform the WCP that the civil suit was dismissed or settled, and the DCP will dismiss their complaint as well. So those are really the biggest changes and amendments to this. And like I mentioned before, as a takeaway, it's really good just to kind of reevaluate your policies and make sure that you're compliant so you won't be burdened with this additional step you have to take. And if you have any questions, you can reach out to me or anyone in the labor department here in New York City.
Thank you so much, Lance. Really glad that you could come on and help the group get caught up on the ESSTA activities. I wanted to just assure all of you who have entered questions in the chat, and it's been very active there today, which is great. We will do our best to answer you offline because we are nearly at time, but we do log all of the questions that you ask, and the attorney to whom you pointed your question will get back to you. In terms of programming that's upcoming, Kristen Smith will be with you next week, and then I'll be with you in 2 weeks. As I noted, both Kristen and I will be keeping you up to date on activity in the legislative space in New York State. There are some speakers who we had scheduled initially this week who will be on next week. We made some adjustments, including to include Tom with that breaking news about Dartmouth. So just stay tuned because we will have plenty on the agenda in the upcoming programming for the balance of February. If you'd like to contact any of today's speakers, you see the email addresses on the slide that's on your screen. If you have any questions at all that you'd like to bring to the team, don't hesitate. In the meanwhile, we just thank you very much for your loyalty to the program. We look forward to being with you the next time you tune in. In the meanwhile, have a terrific afternoon.